name is Ryan, and I am joined today by my colleague Erika. So, in the spirit of reconciliation, the Fair Work Ombudsman acknowledges the traditional custodians of country throughout Australia and their connections to the land, sea, and community. We pay our respect to their elders, past and present, and we extend that respect to all Aboriginal and Torres Strait Islander peoples today. Now, like many international students, you may be looking to get part-time or casual work to get some work experience while you study in Australia. And it's important that you know your rights in the workplace. So in this webinar, we will provide you with workplace essential information, including handy tips to help ensure your workplace rights and entitlements are met while you're working in Australia. Now, as Rebecca mentioned as well, the information that we are sharing with you today is general in nature and current at the time of this presentation. Therefore, our webinars are not recorded. So I believe we have shared that link into the chat there. We do run regular webinars on a regular basis for different audience groups or industries. So you can visit us at www.fairwork.gov.au/webinars to see what we have coming up in that space. And of course, during the presentation, if you would like to ask questions, please do so using the Q&A option. We will endeavour to answer as many questions as we can at the end of the presentation, and your questions also help us to determine what information we can prepare for future webinars. I do also want to let you know that we can't provide information on hours of work or other conditions dictated by your visa, so a student visa. So for information on your visa conditions, you will need to contact the Department of Home Affairs on 131 881. That's if you are in Australia. If you're outside of Australia, the number is +61 2 6196 0196. And equally, if you do have questions on taxation or superannuation conditions, you can contact the Australian Taxation Office on 131020 if you're in Australia, or if you're outside Australia, it's +612 6216 3444. So that's if you're outside Australia. And if you are working in Australia already and you are having issues at work, you can contact us, the Fair Work Ombudsman, directly, and we will provide those details. We've put some into the chat already there for you, but we will also cover those off at the end of the presentation. Now, to start with, before we get into the main presentation, I'd like to run a quick poll about whether or not you've heard of the Fair Work Ombudsman before. So, Raf, if you could share the first poll for us. We'll give you a little bit of time to fill that one in, just to determine whether or not you have heard of us before, or whether you've come across us in preparation for coming to Australia or getting ready to study. Okay, that should be enough time. Okay, so let's get started. Now, firstly, I'm going to tell you a bit about what the Fair Work Ombudsman does. So in Australia, all employees have rights at work, and these rights are protected by laws. These rights also cover employees like visa holders, including international students, regardless of the length of their stay in Australia or their visa type. So the Fair Work Ombudsman is the federal government agency known as the National Workplace Regulator, and we provide workplace advice and assistance to individuals and organisations for free. We are impartial and we don't represent any party. That's an important point as well, because we sometimes encounter misconceptions about who we can assist. Our free services and advice are available to all workplace participants, so that's employers, employees, and their representatives. We also help resolve workplace issues, and we have tailored tools and resources for all workplace participants, including international students. So let's have a look at where employee entitlements can come from. So they can come from a number of different places. The primary source of entitlements is the Fair Work Act, which contains the National Employment Standards or the NES, which are 11 basic entitlements that all employees covered by the Fair Work system in Australia receive. And we'll talk a little bit more about the NES in the next slide. The next source there of entitlements is usually either an award or an agreement. So an award is a document which sets out minimum pay and conditions. It tells employees what they should expect from work and what their responsibilities are to their employer. Some awards cover certain industries such as fast food, restaurants, kind of thing. Other awards cover jobs such as nurses or teachers. The enterprise agreement or registered agreement is an agreement that applies to one business or organisation or a group of businesses to cover all of their staff. So as an example, the Fair Work Ombudsman has an enterprise agreement that covers employees like myself and Erika. And finally, an employee's entitlements might come from an individual or arrangement, which can include things like a contract of employment or a letter of offer. You can have a contract with your employer, but those conditions must be equal to or better than what the award or agreement or the National Employment Standards provides you. The important thing to remember is that these sources operate in a hierarchy. An individual arrangement cannot undercut an employee's minimum entitlements under the Fair Work laws or the award or the enterprise agreement or registered agreement. So as I said, let's have a quick look now at the National Employment Standards. So these are a set of standards that are come from the Fair Work Act that all employees in Australia are entitled to. All 11 entitlements are available to all employees in Australia, but some entitlements might not be relevant to you as international students. So for example, long service leave, if you're only working temporary in Australia, you may not work long enough to be eligible for long service leave. However, there are some entitlements that will be relevant. So maximum weekly hours, which is 38 hours per week plus reasonable additional hours. An entitlement to annual leave, or what we call holiday leave. So that's 4 weeks paid annual leave each year for the full-time employees, proportioned for part-time employees depending on the number of hours worked each week. There's also an entitlement to personal and carers leave, which is also known as sick leave or contains sick leave. And that's leave that you can take if you are sick or have to look after an immediate family member. You get 10 days paid leave per annum for full-time employees, and for part-time employees, they receive this on a pro rata basis, so based on the amount of ordinary hours of work that they would work each week. And these leave, both sick leave and holiday leave, accumulate from year to year. Now, all employees are also entitled to 10 days of paid family and domestic violence leave per 12-month period. So this, different to annual leave and sick leave, this includes both full-time and part-time, but also casual employees have that entitlement to the paid leave. Now, we have a family and domestic violence fact sheet that I will share in the chat that has key information on this entitlement. And the fact sheet covers topics of interest, including when the leave can be taken, how it's paid, notice and evidence requirements, things like privacy and rules around pay slips, and it also contains an example about accessing the entitlement. Another entitlement from the National Employment Standards that students are entitled to, or would be relevant, is public holidays. So this is a right to be absent from work on a public holiday. If you're asked to work, you can refuse if it is reasonable to do so. There's also an entitlement to notice of termination. So employers must give their full-time and part-time employees notice before ending their employment. The amount of notice will often depend on how long the employer has been working for the employer. Also worth noting that this does not apply to casuals. This is only for full-time and part-time. And finally, the right to receive the Fair Work Information Statement and the Casual Employment Information Statement. So employers have to give every new employee a copy of the Fair Work Information Statement before or as soon as possible after they start their employment with their new employer. They also have to give every new casual employee a copy of the Casual Employment Information Statement at the same time. I'm now going to pass over to Erika, who's going to take you through some different types of employment.
Thanks, Ryan. Hi, everyone. So in Australia, there are different types of employees. So generally, employees are either full-time, part-time, or casual. We see a lot of confusion between part-time and casual employment, and this leads to significant errors as their pay and entitlements to conditions like annual leave are different. So let's have a bit of a look at some of the differences. So with full-time employees, they generally work 38 hours per week. They will generally be paid for a full week's work, and they will receive entitlements like paid annual leave, which is also known as holiday pay, and personal leave, which may also be known as sick leave. They will receive notice of termination depending on how long they've been employed. So for example, if you've been employed between 1 year and 3 years with an employer, then your notice period would be 2 weeks. So with part-time employees, they also work regular hours each week, but these are usually less hours than full-time employees. So they will receive the same minimum entitlements as full-time employees, like entitlements to paid annual leave and personal leave. But these are worked out depending on how many hours you work in the week, and this is called pro rata. Similarly to full-time employees, part-time employees also receive notice of termination. So with casual employees, it's considered casual if they accept an offer for a job from an employer, knowing that there is no firm advance commitment to ongoing work with an agreed pattern of work. So to work out whether there is no firm advance commitment, only 4 factors need to be considered. And these are whether the employer can choose to offer work and the employee can choose whether to work or not. The employer offers work according to their business needs. The employment is described as casual, and the employer will be paid a casual loading or a specific pay rate for casual employees. Casual employees have access to a number of entitlements under the National Employment Standards, also known as the NES. Some of these entitlements include being provided with the Fair Work Information Statement and Casual Employment Information Statement, a pathway to becoming a permanent employee, 2 days unpaid carers leave and 2 days unpaid compassionate leave per occasion, paid family and domestic violence leave, unpaid community service leave is the last one. So casuals generally don't get notice of termination or redundancy pay. However, casual employees are entitled to be paid a casual loading or a specific pay rate for being a casual employee under awards and agreements. A casual employee's employment contract or a workplace policy might also provide for more beneficial pay or other employment terms and conditions. So it is really important to check these kind of documents to see what they might say. We have resources for casual conversion, including checklists and template letters for employers and employees. And relevant links are going to be shared in the chat so you can download a copy. All right, so let's have a look at the current national minimum wage. There are different mandatory minimum rates of pay for different jobs in Australia. For most employees, their minimum wage is set by the award that covers their industry or occupation. For some employees, an enterprise agreement or another registered agreement sets their minimum rates of pay. The national minimum wage applies to employees not covered by an award or a registered agreement. So as a result of the 2023 annual wage review decision, the national minimum wage increased from the 1st of July this year. So for employees who are not covered by an award, enterprise agreement, or another registered agreement, the national minimum wage is $23.23 per hour, or $29.04 per hour for casual employees. So lower rates may apply to juniors who are under 21, apprentices, trainees, and employees with disability whose disability affects their productivity. Award minimum wages also increased from 1 July this year. Some award minimum wages may now be less than the national minimum wage. So, for example, some awards contain introductory pay rates for new employees in their industry. So these rates generally apply for a limited time until employee progresses to their next level. So if you're covered by an award or agreement, the national minimum wage does not apply. Minimum wages will be set by those instruments instead. These increases to the national minimum wage and award wages applied from employees' first full pay period starting on or after 1st of July this year. The national minimum wage and award wages are reviewed every year. Now, we did have a question on registration about understanding junior rates. So as I mentioned earlier, junior employees may be paid less than adults. A junior employee is an employee under 21 years of age. Juniors get paid a percentage of the relevant adult pay rate unless the applicable award or registered agreement doesn't have junior rates. If there aren't junior rates in the award or agreement, then juniors are entitled to be paid the same as adult employees. The percentages that apply are usually based on the employee's age and increase on their next birthday. So if you're covered by an award, you can also use our pay and conditions tool on our website to find out applicable pay rates under the award. So employees must be paid at least monthly and can be paid by one or a combination of the following. So you could be paid in cash, via cheque, money order, or postal order, payable to the employee. You could be paid by an electronic funds transfer, which you may also refer to as an EFT or a bank transfer. Most awards, enterprise agreements, or registered agreements will set out when employees must be paid, which is usually weekly, fortnightly, or monthly. And they may also set out the methods by which employees are to be paid. If not, employees must be paid at least monthly and by the methods that I've mentioned. So there is a difference between being paid what is known as cash in hand or being paid in cash. It is okay for an employer to pay wages in cash, and you should always receive a pay slip to cover the amount. If an employer pays cash in hand, this may mean they are not withholding the required tax, they may not be paying you superannuation, or not providing you with a pay slip, which is unlawful. However, if you're paid cash in hand, you still have the protection of the Fair Work Act and the National Employment Standards. While your employer could break the law by not withholding tax and not providing you with a pay slip, you are not breaking the law by being paid cash in hand. Okay, so making an employee give back some of their wages is a practice sometimes referred to as a cashback scheme. This can occur, for example, where an employer pays an employee the correct pay rate and then makes the employee give some of it back. This is unlawful. Also, an employer can't ask a prospective employee to pay money just to receive a job offer, ask employees to pay money to keep their job, apply unfair pressure to employees to spend their pay or own money. And if an employer breaches this workplace law, the employee will still be entitled to have this amount back paid by their employer. Amounts paid by prospective employees can also be recovered, whether or not they start with the employer. I'll now pass back to Ryan, who will have a look at some of the common issues you might encounter in the workplace. Thanks, Ryan.
Thank you, Erika. So now that we have gone through some of the minimum entitlements, I want to go through some of the common issues that you might find in the workplace. So one of the most common that we come across is non-payment for work. So sometimes an employer might ask you to do an unpaid work trial to evaluate you for a job you're applying for. This is used to determine if you are suitable for the job by getting you to demonstrate your skills. Now, these kind of trials are okay if it is just for the purpose of you demonstrating the skills required for the job. So an example that we use is that if you are looking at going for a job as a barista or a coffee maker at a cafe, an employer might look to assess your ability to make different types of coffee orders. You must be directly supervised during the trial, and the trial can only last as long as it's necessary for you to demonstrate that you have the required skills. If an employer then wants to further assess your suitability after that trial, then they need to employ you either as a casual employee or for a probationary period or both. And if the employer does this, then you must be paid for all hours worked. You must also be paid for the right pay for any time spent in compulsory training, whether it is in person or online or off-site. You must also be paid for attendance at team meetings or opening and closing the business outside of the core hours if your employer requires you to be there. Another issue that we come across is unauthorised deductions. So these are deductions from an employee's wages to cover things like losses, breakages, till shortages, and covering customers who don't pay. These deductions are actually unlawful. So deductions can only be made in very limited circumstances and usually need to be for the employee's benefit. Another issue is being paid in goods and services instead of money. So this is also known as payment in kind, and it is unlawful. So we've heard of businesses who are paying staff in pizza instead of money, that kind of thing. So as an employee, you must be paid wages, monetary wages, for all work performed. Another common issue, and a very common issue, is employees not being provided with pay slips. So as we mentioned, pay slips must be given to an employee within 1 working day of payday, even if an employee is on leave, and it's got to be made available to them. Pay slips can be in either electronic form, so via email, or given as a paper copy or a hard copy. And electronic pay slips must have the same information as paper pay slips. So pay slips must contain minimum information, such as the business name, the Australian business number. Then it's got to have you as the employee's name, the date of payment of wages, and the total amount and net pay, or gross pay and net pay, and any deductions that are made. So there is a full list of what needs to be on a pay slip, and that's available on our website as well. You can find the payslip section there. And as we mentioned earlier, employees have to give every new employee a copy of the Fair Work Information Statement as soon as they start their job, and if applicable, casuals need to be receiving a copy of the Casual Employment Information Statement. Now, looking a little bit further at some unpaid work arrangements, for young workers, unpaid work can take on different forms, and these can include things like vocational placements, unpaid internships, unpaid work experience, as well as the unpaid trials we covered on the last slide. We did have a couple of questions on registration, particularly about student placements in particular. It is important to know that some kinds of unpaid work, like in unpaid internships, can be unlawful. To help you assess whether an unpaid internship is lawful or not, there are some things that you need to consider. So firstly, is the internship a student or vocational placement? And what we mean by that is it a course requirement that has been approved by a government or a government body as part of a qualification? If it's not a student placement, Then, is there an employment relationship? So, some things to consider when trying to work out whether there is an employment relationship include what the nature and purpose of the arrangement is, how long the arrangement is for, how significant the arrangement is to the business in terms of how much productivity they would be getting from you, what are the employee's obligations, and who benefits from the arrangement most. So you can find more information about unpaid work on our or in our unpaid work fact sheet, which is both available on our website at fairwork.gov.au/unpaid work. And we've got some videos as well, one of which is on the screen there. You can see about unpaid work that are available through our YouTube channel, and I will show you how to access those at the end. But you'll be looking to start some new employment. Erika is going to take you through some of the vital things that you need to know.
Thanks again, Ryan. So we did have a few questions from some of you on registration asking what people should know or how best you can prepare before you start a new job in Australia. So we'll go through a few things now that you should know. So firstly, it's really important that you know your employer's business name and the ABN, which is also known as the Australian Business Number. So it's worth taking the time to find an employer that pays correctly and doesn't try to take advantage of you. So try not to respond to questionable advertisements where there is only a first name and a mobile number provided. And know who you are working for. Ask the question, what is the business name and what is the ABN? So secondly, it's good to know whether you are full-time, part-time or casual. So as we mentioned earlier, the type of employment will affect your hours of work, your rate of pay, and some of your entitlements, including paid annual and personal leave. If you are not sure, you should ask your employer. Next, know what your main duties will be. So do you know your main duties? If not, make sure you follow this up with your employer, or you could also ask a supervisor at the workplace. Know what award or agreement covers you. So we talked about those earlier. So employees are likely to be covered by an award or an enterprise agreement or another registered agreement. The applicable award or agreement will outline your entitlements such as the minimum rate of pay, penalty rates and breaks. So know what pay rate you will receive. You must be paid at least the minimum wage in your award or agreement. If your award or agreement free, you must be paid at least the national minimum wage. The applicable minimum rate of pay may depend on a number of factors such as age, experience and duties of work. If you're covered by an award or agreement, you may also be entitled to more money, such as penalty rates for working weekends, evenings and on public holidays. So next, know when you will be paid and how. It is important to find out how you will be paid, whether it's cash, via EFT, so bank transfer, check, and how often, whether it's weekly, fortnightly, or monthly. Lastly, know what paperwork you need to receive. So as a new employee, before or as soon as possible on commencement, you should receive a copy of the Fair Work Information Statement. If you are a casual employee, you should also receive a copy of the Casual Employment Information Statement. So once you've started your job, you also need to receive a payslip within 1 working day of payday. It's also a good idea for you to ask your employer for a letter of engagement or contract. This should tell you everything you need to know about the duties, hours of work, and your job. So for more information on starting a new job, employees can check out our Starting a New Job Guide and checklist on the Fair Work Ombudsman's website. We also have an online training centre where you can find a workplace basics quiz, as well as an online training course called Starting a New Job. All right, so next we're going to have a look at the visa protection, the assurance protocol. So as I mentioned before, all people working in Australia have the same basic minimum workplace rights and protections, regardless of their citizenship or visa status. Your rights can't be taken away by contracts or agreements. We make sure the rights of visa holders are protected and enforced fairly under Australian workplace laws. Your employer can't cancel your visa, even if you've breached your visa conditions. So only Home Affairs can grant, refuse, or cancel visas. We have an agreement with Home Affairs to support visa holders who come to us for help. Visa holders can seek help without fear of visa cancellation, even if they've breached their work-related visa conditions. This arrangement is called the Assurance Protocol. All right, so let's have a bit more of a look about what the Assurance Protocol is. So under the Assurance Protocol, Home Affairs usually won't cancel your visa if you have breached your work-related visa conditions because of workplace exploitation and you have sought advice or support from us and you're helping us with our inquiries. There is no other reason to cancel your visa. So for example, for national security, character, health, or fraud reasons, and you have committed to following your visa conditions in the future. For temporary visa holders who don't have permission to work attached to their visa, Home Affairs will consider each case on its merits. So the Insurance Protocol only applies to visa cancellations and does not apply to other visa grants. So I'd encourage you to check out our website for further information about the Assurance Protocol, including who it applies to and how it works at www.fairwork.gov.au/migrant workers. All right, so let's have a look at what you might need to do to get some help from us. So if you face any workplace issues or have questions about workplace rights, you can contact us. We are responsible for ensuring workplace laws are complied with and provide free help and advice to employees and employers. It is understandable that you or someone you may be assisting may be worried about asking questions, making a fuss, or complaining about what is happening at work. But it is okay to ask for information or for help. It is against the law if an employee is sacked or terminated from employment because they asked about pay or other entitlements, or they contacted the Fair Work Ombudsman. So when someone contacts the Fair Work Ombudsman, their information is kept confidential. We won't contact their employer unless they want us to. You can also choose to report anonymously through our anonymous tip-off form, which is located on our website. So next we're going to have a look at a case study video, and this details how easy it is to get help from the Fair Work Ombudsman. This video features Philippe, who is an international student, and he shares his story about how we helped increase his awareness of workplace rights, including busting this common workplace myth.
My name is Felipe. I'm 22 years old. I come from Brazil. I currently study in Australia and I also work as a part-time waiter at a cafe. When I started, my boss offered me $17 an hour, which I thought it was really good because this rate was much higher than what I could get paid in Brazil. I get paid into my bank account and on the same day I receive a payslip. After about 6 months, I was talking to one of my friends about our cafe jobs, and I realized I was paid less than the legal minimum wage. I got a bit worried because I agreed to the rate when I started working at the cafe. I thought I broke the law by agreeing to a rate that's lower than the legal minimum wage. I told my friend about my concerns. Then he told me I could ask the Fair Work Ombudsman, a government agency, for help. So I did. To be honest, I was a bit surprised by how easy the process was because I had never contacted a government agency for help. I lodged an online inquiry through the Fair Work Ombudsman My account, and not long after, an advisor contacted me to discuss my situation. He told me about my workplace rights, including the minimum wage that I am entitled for my job. He also said that it doesn't matter that I am an international student. I am entitled to the same workplace rights as any other worker in Australia. And I didn't break the law for agreeing to receive less than the legal minimum wage. I was so relieved to hear that I was in any kind of trouble and they could help me. The advisor told me how to get information about workplace rights from the Fair Work Ombudsman website, including the rates of pay that I'm entitled to. They also summarized the information we had discussed in my account inquiry, so I could refer to it whenever I needed.
Okay, sorry if that video was a little bit lagging or behind, but we will be sharing a link in the chat box for you. And we also have another international student video from Jessica, so you'll have access to both of those if you'd like to look at them after the presentation. We also have case study videos for migrant worker and a small business owner, for those of you who might be interested in starting your own business. So we'll also share those links for you in the chat. So now we're going to have a look at some recent legislation changes. So there's been a recent change to Australian workplace laws, and this is known as Secure Jobs, Better Pay. So the Fair Work Act has recently been amended to change a number of existing rules and include a range of new laws. So many of these changes started on the 7th of December last year, but other changes start later. So the timeline in the slideshow shows key start dates for these important changes. So as you can see, many changes have already started, such as prohibiting pay secrecy and unlawful job ads, specifically on job ads from the 7th of January this year. Job ads can't include pay rates that undercut employees' minimum entitlements. So this requirement applies from the 7th of January, regardless of when the ad was originally posted. So I strongly recommend that you read in more detail about these changes on our website. So in addition to the Secure Jobs, Better Pay amendments, there has also been some further changes to protect worker entitlements. So on the 22nd of June this year, the Australian government passed the Fair Work Legislation Amendment Protecting Worker Entitlements Act. The legislation introduces changes to the Fair Work Act. The changes have different start dates. Some take effect now, while others start later this year or in 2024. So the key changes are right to superannuation in the National Employment Standards, changes to unpaid parental leave, interaction between enterprise agreements and workplace determinations, authorised employee deductions, protections for migrant workers, casual employees in the black coal mining industry. Specifically on the protections for migrant workers from the 1st of July this year, there is now clarity on their protections. So migrant workers in Australia have always had the same rights and entitlements under workplace laws as other employees working in Australia, but this change clarifies that migrant workers continue to have these rights and entitlements regardless of their migration status under the Migration Act 1958. And a breach of that act doesn't affect the validity of an employment contract or a contract for services. So this includes circumstances where a migrant worker has breached a condition of their visa, doesn't have work rights, or doesn't have the right to be in Australia. So to find more about the changes, please visit www.fairwork.gov.au PWE, and a link is being shared with you now. So now I'll hand you back over to Ryan, who will show you some information about our website that we've touched on throughout the presentation today. Thank you.
Thank you, Erika. So we are going to switch to a live demonstration now. I'm just going to bring up the page. So this is the Fair Work Ombudsman website. And I'm going to turn my camera off so you're going to focus and I can sort of work through the website here. So can you hold on? Okay, so this is fairwork.gov.au. It's the home of all of our content, all of our free resources, many of which we have talked through today. As you can see on the front page, the information is broken up into the two most prominent areas we get inquiries about, being pay and wages and of course leave. And then the rest is broken down into the life cycle of employment, from starting a job through the conditions of employment, where these employment conditions can come from, through workplace problems, and then eventually things you need to know about ending employment. I am going to take you through some of the more relevant pages that may be of interest to you. And we're going to start today up in this menu box at the top. I'm going to go down to Find Help For, and we're going to start with visa holders and migrants. So those of you who are coming to Australia and are looking to find work, we have a dedicated visa holders and migrants page, which has useful and practical information about your visa, about the assurance protocol, and some information about paying conditions as well, including one of the case studies that we've just recently launched here. There's some information about those protections that Erika has just gone through as well, and a few resources there that may be useful to you, particularly around visa information and sponsorships. Students as well, another good resource that you can go to. Again, it's under the Find Help For section, and we're going to look at young workers and students over here. So again, this is another dedicated section with information for young workers and students, where you can find out, again, about your minimum wage and some guides on how to resolve workplace issues. But also in terms of some of the stuff that we have talked about today, there's information here on unpaid trials, on student placement, things like the work experience and internships. We've also got information specific for international students, including this international student fact sheet, which is something that may have some very useful information there if you are looking at studying or are studying in Australia as well. And there's a dedicated section with information as well on myths and like common workplace issues as well. Now, another area that we did have questions about, and while we do have a bit of information on here, we weren't able to cover off completely, but again, under Find Help For, information for independent contractors or those who are looking to work under an ABN or as a contractor, or working in the gig economy. So things like food delivery or rideshare services. So we've got some information tailored to assisting independent contractors and those who are working in the gig economy, including some information about the differences between contractors and employees, what some of those entitlements might be, in terms of the differences there. A few case studies that may be useful there, and particularly as well, if we go back to the top, a dedicated portal to the gig economy, so, or app economy as it may also be known. Next up, we did mention earlier that you can calculate wages on our website. So if we go up under the pay and wages section, and we go to check or calculate pay, and I am just conscious of time, so I'll just give you a bit of an overview of this one, but I would encourage you to have a look. So we have a pay and conditions tool, which is actually 4 calculators. It's a pay calculator, a shift calculator, a leave calculator, so to calculate things like your annual leave and sick leave, as well as a notice of termination and redundancy calculator. But what it is, it's a series of questions that you can go through, and as long as you're going through and you're answering these questions, it will come through and provide you with your minimum wages. So at any point, if you're unsure of what's asking, you can click these question marks and it's going to give you a little bit of a breakdown. And if you do see an arrow, you can drop one of these down as well, and it'll give you a bit of a guide as to what that award will cover. So I would encourage you to have a look at that. And again, you just need to access that through the menu section and under pay and wages. Another one that is important to find information for is workplace problems. So we have a dedicated section to help you prevent workplace problems from happening, as well as providing information on how to resolve problems in the workplace. So the section is divided into the three main stages of problems. So preventing workplace problems, looking at some common workplace problems, some that we took you through today in the webinar, and how you can go about fixing or resolving or getting our help with workplace issues. We've also got a third section where you can send us if you are uncomfortable in coming to us and raising an issue. We do have a section for anonymous tip-offs. This one's also important because you can do this both in English or in your own language. So there is a portal to be able to do that. By putting in an anonymous tip-off, while it doesn't necessarily guarantee that we can resolve the issue, the information does help us to look at where issues are occurring and to design some of our compliance activities around the information that we get in. So it is very useful information to us. But if you're wanting assistance, then have a look under that workplace problem section, and we can certainly look to provide some assistance there. While we're on the subject of things that are in language, back up into the menu and under tools and resources, we've got a language help section. So what this is, we have professionally translated a number of our resources into over 30 languages now. And this contains a lot of useful information that have gone through that translation service. So as a bit of a guide, I'll show you the English version just so we can talk through some of it, but this will be the same for each of the pages. We've got useful information on, again, pay. We've got translated information statements, so both the Fair Work Information Statement and Casual Employment Information Statement. We have videos that have been translated in languages, and a few other resources there as well. You also have the option up the top here is you can translate the rest of the website through the Microsoft Translator plugin. What this will do is by selecting your language, it will translate all of the Fair Work Ombudsman, and it will remember, so the browser will remember your selected option. So each time you come back, you will be able to pick up from where you left off. It'll have those translated resources there again. Finally, I will show you, so if you have enjoyed the webinar today and you've learned something and you're wanting to continue on your learning journey, we have an online learning centre which has a couple of really useful online courses for employees. Now, like everything on our website, all of these resources are free, and the two courses that we have specifically for employees at the moment is the Starting a New Job, which is similar to the guide that we showed you and talked you through earlier, but it's going to give you an interactive scenario to work through. It takes between 20 and 40 minutes to complete, but the Starting a New Job guide will give you a basic understanding of what your rights are and what questions to ask and what type of behaviours are expected in the workplace. We've also got the Difficult Conversations in the Workplace course. So that provides you with information on how to handle difficult conversations with your employer to resolve workplace issues, including tips to help you prepare, manage your emotions, and reach positive outcomes. And once again, it's full of interactive scenarios to help you practice having those difficult conversations. Now, this one as well, we mentioned earlier about the new entitlement to paid family and domestic violence. The Difficult Conversations in the Workplace courses now has information within there to help have those conversations around family and domestic violence as well. So provides information on responding to disclosures and maintaining confidentiality, and has some referrals and supports for employees who may be experiencing family and domestic violence as well. So there's plenty more on our website as well. Again, plenty of tools and resources, plenty of specific pages for those who are interested. So I would encourage you, if you are interested, to have an explore of the website in your own time. I'm going to go back now to the presentation, which we covered off on. Okay, so here's a slide with some of the tools and resources that we have available to help, some of which we have already discussed. But at this point, we'd like to run our second poll, and I'll get Raf to help us again with this. So the question this time is, following this presentation, do you think your understanding of Australian workplace laws has improved? So please let us know yes or no. If you do select no, we'd love to hear how we could improve this presentation and what other areas we could cover off on. So if you can provide feedback or any further questions you have through the Q&A box. And like I said at the start, the feedback and questions will help us to determine areas where we need to develop further resources or information, particularly for parties like yourself. So we'll give yourself a little bit of time. And we'll have a look at some contact details. Okay, that should be a good time. Okay, so as we said earlier, there are, if you do have specific issues, definitely get in contact with us, or if you do have questions, these are the ways you can get through. We did share them in the chat earlier, but you can visit our website, as I showed, at fairwork.gov.au, and you can subscribe to our email updates, the link on the screen there. You can contact our Fair Work info line on 131394. And if you need interpreting or translation services, you can contact the translation and interpreting services on 131450. We've got our social media channels up in the top right-hand corner, including the Fair Work, so on Facebook, Instagram there, LinkedIn and Twitter. And as we shared at the start as well, we are regularly delivering webinars tailored for different audiences and industries. So please check out our dedicated webinar page at fairwork.gov.au/webinars for information about some of the upcoming webinars that we have. So that concludes the presentation. We now have some time to answer some questions. And as a reminder, as I covered at the start, we are unable to answer any questions relating to conditions specific to visas or taxation matters. And we can't provide advice on individual matters or issues that you might be having. So for individual matters, I would encourage you to contact us with the details that are on the screen. But happy to hear if we have any questions coming through.
Amazing. Thank you so much for that enriching presentation, Rian and Erika. I'm sure that our viewers gained a lot of very valuable insights from it that will help them during their time here in Australia. So as Rian mentioned, that now brings us to the Q&A portion of today's webinar. So we'll be answering some questions that we received both during the registration process as well as in the chat during the presentation. So first up, you mentioned briefly in your presentation about student placements, but we've been asked for further clarification on whether the same workplace rights apply for students who are on placement as they would in any other workplace. So can you elaborate a little bit further on that?
Okay, so when we say sort of like in terms of protections and entitlements, what are we specifically looking at, like in terms of wage rates or because with some student placements, vocational placements, there may be appropriate arrangements where those are unpaid, where they are part of a vocational course. So they're not necessarily going to have the same rights and conditions as a regular sort of employment relationship. So if that, in terms of that, yeah, there may not be those same coverages. But again, where it is a legitimate vocational or student placement, then that may be an acceptable arrangement.
Right. Yeah, no, I think that's definitely great for our audience to know. Another question that we got from our audience today.
It depends largely. Sorry?
Yeah, sorry. Did you want to elaborate further?
Hang on. It's my turn to have some audio issues again.
Oh,
sorry,
no.
can you just repeat that?
Maybe I'll just touch on what the next question was, and perhaps Erika, you might be able to jump in here while Ryan kind of sorts out his audio. We did have a question that sort of touched on the aged care working hour restriction exemption, basically. So for student visa holders working in aged care at the moment, it is stated that they are currently allowed to work unlimited hours in Australia until the 31st of December 2023. So we received a question about whether this applies to those who work with allied health providers providing allied health services to aged care patients, or if this just applies to staff that are working in aged care facilities. So are either of you able to kind of speak to that at all?
I believe that one.
Like
Sorry, Ryan, you go.
No, so that's all right, Erika. So yeah, like as we said at the top, with those, because it is going to be directed as a student visa condition, but it's sort of pertinent to the specific visa type, we won't have specific information on the kind of breadth of that. So that is something, and I'll give you the phone number again, but you can contact the Department of Home Affairs to clarify the industries that will have the those limitations or exemptions, so to speak. So from inside Australia, the number is 131 881. Or if you are currently residing outside of Australia, it's the extension's +612, and then the number 6196 0196. So they should be able to provide you with what those exemptions and the limitations would be around those industries.
That's great. Thank you so much for that, Ryan. We also received a couple of questions from a couple of our audience members about working in Australia, but for offshore companies, basically, and whether kind of the same workplace rights and obligations kind of still apply. So can an international student have a full-time job working remotely within Australia for a company that's located outside of Australia? Is that allowed? Are you kind of able to speak a bit more on that?
Like in terms of, so if they've got a like an Australian operations, but they're based outside of Australia, but for all intents and purposes, the Australian operation has its own ABN and they're being paid in Australian currency or from an Australian office, then they would have the protections of the Fair Work Act and the National Employment Standards. So we're obviously in a global economy, so a lot of international businesses set up in Australia and around the world. If it's something where they are working for a company that is based and they're being paid from overseas and they're being sent to work in Australia, a little bit of a different story, and some different things may apply with that. But if they are working for a company that is established in Australia and being paid through an Australian payroll, they've got all the protections of everyone that's working in Australia.
Okay, absolutely. And in terms of whether that would kind of be allowed on a student visa and whether that would be in breach of kind of the working hour condition, would that kind of be again the jurisdiction of the Department of Home Affairs, and that's kind of
once again, yeah. So in terms of the differences, if they're working again at what's considered sort of hours of work in Australia, again outside of what we can really provide information on. So definitely speak to Home Affairs on those details provided.
For sure, absolutely. And this next question that we received from an audience member, it might be the same thing, but I'll kind of throw it out anyway, just to see if you might have any additional insights. But someone asked if someone has a leave of absence from university, do they kind of have unlimited, working hour rights? Do they have the same work rights until they return to their studies, or is there a difference there if they're on a leave of absence?
I mean, in terms of their rights at work, certainly they've got the same rights as anyone else working in Australia. the limitation or where the visa conditions come in may vary. So, but that's what they would speak to in regards to the Department of Home Affairs. But for just general conditions of employment, their wages and conditions while they're at work, no, even if they're at a leave, they still have the same protections as anybody else working in Australia, and would still be able to get the support of the Fair Work Ombudsman if they needed it.
That's great. Okay. We also had Louise, who asked a question about unpaid break time. So I know in the presentation we kind of touched on the different types of unpaid work and kind of when unpaid work is acceptable and things like that. But this question specifically kind of pertained to whether unpaid break time, such as a 30-minute unpaid lunch break, for example, would kind of be counted in the student's working hour limit. And again, perhaps because this sort of pertains more to the working hour, a restriction or cap, maybe this isn't, again, within the remit, but are you able to speak to that at all, or is
I can give a little bit. So again, it's we can't sort of speak on what the visa conditions are, but where it's like the meal break example that you've used. So where they've got a meal break, for the purposes of us calculating ordinary hours, a meal break wouldn't count towards that because it wouldn't be counted as part of those ordinary hours. So when we talked about the National Employment Standards and the 38-hour maximum a week, those 38 hours wouldn't include those unpaid meal breaks. Having said that, again, visa conditions, I can't speak on that. So again, would need to be confirmed with the Department of Home Affairs as to whether or not that would be counting. But for the purposes of in terms of payment and time at work and ordinary hours, no, an unpaid meal break wouldn't count as that.
And we also had a question about sort of the difference between an ABN, so an Australian business number, versus a TFN, so a tax file number.
Yeah.
Do different workplace laws apply to each, depending if a student is working on one or the other?
Yeah, so if you're an employee working in Australia, so an ABN is an Australian business number, and that applies to businesses. Now, when someone works under an ABN, we would say that they are working as an independent contractor, so they're essentially their own business. And what that means, for the most part, is that they don't have the access to, because they're not actually deemed an employee, there's not the employee relationship with who they're providing for. They're essentially a business providing a service to another business or businesses when they're on the ABN. So they will be negotiating their own pay rates, they will be covering their own taxes, and they would be invoicing for their pay. So it's not actually the same as their employee relationships, which you would have by getting the tax file number. So when you're working directly for an employee, you do have the protections of the Fair Work Act. There are protections for independent contractors and there are acts that look after certain conditions, but in terms of the things like minimum wage rates, like penalty rates, getting certain allowances, annual leave and sick leave, they are only conditions that apply to people who are employees, so not applying to contractors. There is, I'm just trying to think, like I said, we did show you that there's a portal on our website that has a bit more information for independent contractors, and particularly as we see the rise of like the app economy, so things like your rideshare services, your food delivery services, we're seeing a lot more instances where people are working under the Australian business number, but the conditions are different, and you don't have the same protections as employees. So that would be the major difference.
Right. Yeah, no, that's great to know, particularly as you pointed out, the rise in the gig economy, and we're seeing more and more types of work like this. And it's interesting that you touched on, food delivery services as an example, Ryan, because we actually did get a question about, if we're working multiple jobs for Uber Eats, for DoorDash, kind of what are the workplace rights and entitlements under that kind of working structure. So based on what you were saying just now, it would be more the ABN kind of obligations that a student working in this realm would need to focus on more predominantly?
I mean, I would say, like, without knowing the full setup of the companies that you've mentioned and how they operate. I know that there's been certain they've looked at sort of legal structures of that previously. I can't comment too much on that, but certainly there's if a company's asking you to provide an ABN or to look into that, then that would indicate that the expectation is that you'd be working as that contractor. And again, you probably want to have a look at the rights and the differences on our website between employees and look to see, make sure that you are aware of the differences and what potential there is, because sometimes we have businesses that get people to work as contractors when they probably should be engaged as employees, and they do this often to avoid paying certain entitlements, things like your leave provisions, your penalty rates, overtime, stuff like that. And there can be circumstances where that's actually not lawful, and what we would call sham contracting as well. So where people should actually be engaged as employees, but they're not. Again, information on our website around sham contracting and what you can do if you believe that you are under a sham contracting arrangement in terms of getting support and assistance from the Fair Work Ombudsman. So I would definitely encourage people, if they are concerned, to have a look at that section as well.
Great. Thank you so much for that, Ryan. And that was all of the questions that we had kind of compiled for our Q&A period.
Right.
So I just want to take a moment to just say thank you so much to yourself and to Erika and for the FWO in general for today's informative webinar. We hope that everyone who tuned in today had their questions answered, and more importantly, kind of learned more about how the FWO can support you with any questions or issues that you might encounter whilst working in Australia. So for more information, as Ryan mentioned, please feel free to visit the FWO website and connect with them on social media, which you'll see on your screen still, for updates and important information around your working rights and entitlements in Australia. So thank you both again, and thank you to everyone for tuning in. We will see you in the next webinar.